India Legal presents Court This Week.
Hello and welcome to Courts This Week. I am Tanya. In this special edition, we bring you top stories of legal proceedings from the courts, from lower and subordinate courts to high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
In the matter relating to communal reporting of the Tablighi Jamaat incident, Supreme Court has told Centre to evolve mechanism to address grievances against media. It was the second hearing when CJI S.A. Bobde was dissatisfied with the reply filed by the Centre, as it did not deal with the applicability of Cable TV Networks Regulation Act. The Centre made the submission in an affidavit filed in response to PIL's moved against the communalization of the Tablighi Jamaat event amid the COVID-19 pandemic.
The Supreme Court has asked the central government to evolve a mechanism to deal with complaints against media, expressing dissatisfaction at the reply filed by central government in a petition alleging biased and communal reporting of the Tablighi Jamaat incident. A three-judge bench headed by Chief Justice of India S.A. Bobde stated that the affidavit filed by the centre was silent on the applicability of the Cable TV Networks Regulation Act and the mechanism adopted by the centre to address such grievances and complaints against media. The Ministry of Information and Broadcasting, in its affidavit filed on 13th November, had informed the Supreme Court that the petition against communal reporting of Tablighi Jamaat incident was based on vague assertions and news reports published by certain fact-check websites, and the same cannot be relied upon the content that entire media was spreading communal disharmony. The top court further asked the centre why a private body like the News Broadcasting Standard Authority (NBSA) should look into the complaints against media. The CJI said, "We want to know the mechanism employed by you, and this affidavit has nothing on it. Why should we refer to NBSA, etc., when you have the authority to look into it? If it does not exist, then you create an authority, else we will hand it over to an outside agency." However, the Solicitor General maintained that NBSA was a self-regulatory body. The bench, which also comprised Justices A.S. Bopanna and V. Ramasubramanian, asked the centre to file a reply incorporating all the aspects raised by the court and posted the case for further hearing after 3 weeks. The plea filed by Jamiat Ulema-e-Hind and the secretary of its legal cell, through lawyer Ejaz Maqbool, had contended that the unfortunate incident of the Tablighi Jamaat was being used to demonize and blame the entire Muslim community. At least 9,000 people had participated in the religious gathering at Tablighi Jamaat's headquarters in Nizamuddin West in March this year. The congregation became a key source for the spread of COVID-19 in India, as many of the participants travelled to various parts of the country after the event. This also led to news report by certain television news channel blaming the Muslim community for the incident and attributing motives to them, alleging that it was a deliberate attempt to spread COVID-19 in India. The plea before the Supreme Court sought direction to the centre to stop dissemination of fake news and take strict action against the section of the media spreading bigotry and communal hatred in relation to the incident. In addition to this, there are several fake reports and videos circulating on social media showing Muslim in bad light, the plea contended. The central government had earlier filed an affidavit in the matter, but the top court had objected to the same, stating that it was filed by a junior officer and was not satisfactory. It had then directed the centre to file a fresh affidavit while also asking it to clarify whether or not it had power to ban television channels. Bureau Report.
Supreme Court has held that show cause notice with intention to blacklist should clearly spell out such intention. The apex court noted that blacklisting order can cause civil death of a person as it results in an organization being blacklisted by other government companies too.
The Supreme Court has ruled that a show cause notice with the intention to blacklist the noticee or the person who was sent notice should spell out such intention in clear words so that a person against whom the penalty of blacklisting is intended to be imposed has an adequate, informed and meaningful opportunity to show cause against such possible blacklisting. A vague show cause notice will be in violation of the principles of natural justice, the top court said. The judgment was rendered by a bench of Justices S. Abdul Nazir and B.R. Gawai in a case relating to the blacklisting of a recruitment agency by Food Corporation of India (FCI) after certain question papers by the agency were found to have been leaked. The top court held that for a show cause notice to constitute a valid basis for a blacklisting order, such notice must spell out clearly, or its contents be such that it can be clearly inferred therefrom that there is intention on the part of the issuer of the notice to blacklist the noticee. In the present case, the court concluded that a plain reading of the notice made it clear that the action of blacklisting was neither expressly proposed nor could it have been inferred from the language employed by the FCI in its show cause notice. The FCI sent a show cause notice to the appellant and asked for an explanation. When the appellant sent a detailed reply, the FCI proceeded to ask for another final reply. The FCI then passed an order in January 2019 blacklisting the agency from undertaking FCI projects for the next 5 years. The security amount of the appellant with the FCI was also fortified. The Madhya Pradesh High Court on February 13, 2019 dismissed the challenge to the FCI's order, which led to the appeal before the Supreme Court. The court also asked the blacklisting order can cause civil death of a person as it results in an organization being blacklisted by the other government companies too. It was held that a clear notice is essential for ensuring that the person against whom the penalty of blacklisting is intended to be imposed has an adequate, informed and meaningful opportunity to show cause against him possible blacklisting. The top court therefore set aside the orders passed by the High Court and FCI, holding that the show cause notice issued by FCI was contrary to the principle of natural justice. Bureau Report.
The Supreme Court has upheld the Uttar Pradesh government's decision increasing cut-off marks for 2019 recruitment of 69,000 Shiksha Mitras. The Supreme Court dismissed the appeals filed by Uttar Pradesh Shiksha Mitra Association in a case related to recruitment of 69,000 assistant teachers in the state of Uttar Pradesh. A bench headed by Justice U. Lalit further recorded the state's contention that Shiksha Mitras would be given one last chance to compete in the next recruitment examination, and the modalities of the same would be discerned by the state.
The Supreme Court has upheld the Uttar Pradesh government's decision regarding cut-off marks for 2019 recruitment of 69,000 Shiksha Mitras or assistant teachers to 65 and 60 for the general and reserved category, respectively. The apex court affirmed the Allahabad High Court judgment in this regard and dismissed the appeals filed by Uttar Pradesh Prathmik Shiksha Mitra Association, giving green signal to the UP government to fill the 37,000 Shiksha Mitra vacancies in terms of the results of the recruitment exam announced in May 2020. The apex court, however, held that aggrieved Shiksha Mitra would be given another opportunity by allowing them to compete in the next recruitment examination. The top court left to the state government to work out the modalities with regard to the same. The judgment was rendered by a division bench of Justices U. Lalit and Mohan M. Shanta Kaudar in the plea challenging the decision of Uttar Pradesh government fixing the cutoff marks for recruitment of 69,000 assistant teachers in 2019.
कि बीएड को एनसीटी ने, हमने नहीं, एनसीटी ने जून 2018 में बीएड डिग्री धारकों को भी अलाउ कर दिया भर्ती में शामिल होने का। तो भर्ती में अचानक 2.5 लाख लोग एक्स्ट्रा और आ गए, इसलिए कट ऑफ ऑटोमेटिकली ऊपर चला गया और इसमें कुछ भी मतलब हमारी तरफ से किया हुआ कुछ भी नहीं था। एक नेचुरल, जिसे कहते हैं ना, कॉमन सेंस, रैशनल एक लॉजिक थी।
The bench had reserved its verdict on July 24 after detailed hearing which lasted for over 2 days. The Uttar Pradesh Prathmik Shiksha Mitra Association had challenged the UP government's order of January 7, 2009 by which the qualifying marks for the assistant teacher recruitment examination of 2019 were increased. This notification increasing the cutoff marks was issued a day after the exam for the recruitment of 69,000 teachers in primary schools of the state was held. The Allahabad High Court had confirmed the state government's decision clearing the way for recruitment of assistant teachers in basic education council schools in the state. The petitioners contended that fixing the qualifying marks at 65 and 60 was arbitrary and the same should have been fixed at 45 and 40. They pointed out that the qualifying marks for the assistant teacher recruitment exam in the previous year was 40 and 45. Moreover, it was also their case that the qualifying marks were fixed before the conduct of exams in the past and not after the exam as was done in 2019. It was argued before the two-judge bench that as per Anand Yadav judgment, Shiksha Mitras were entitled to be given 2 consecutive opportunities for recruitment as assistant teachers and were also entitled to weightage for experience at the time of final selection. Appearing for the petitioners, senior advocate P.S. Patwalia had submitted that the teacher eligibility test qualified Shiksha Mitra constituted a separate homogeneous class. Further, the Uttar Pradesh government has been given the go-ahead by the apex court to fill the remaining 37,339 posts of assistant teachers in line with the results announced in May 2020. These posts had been kept vacant by the June 9 order which had stayed the selection process in the state. Bureau Report.
The Supreme Court has issued notices on a batch of petitions challenging the election of External Affairs Minister S. Jaishankar to Rajya Sabha from Gujarat. The pleas have also raised the issue of Election Commission's power on issuance of separate notifications for holding by-polls for casual and regular vacancies in Rajya Sabha. One of the petitions against Jaishankar has been filed by Congress leader Gaurav Pandya.
The Supreme Court has sought the response of External Affairs Minister Dr. S. Jaishankar in a plea challenging his election to the Rajya Sabha from the state of Gujarat. A 3-judge bench comprising Chief Justice of India S.A. Bobde and Justices A.S. Bopanna and V. Ramasubramanian issued notice to Jaishankar and asked him to file his reply by 8th of December. The petition filed by Congress leader Gaurav Pandya has assailed Jaishankar's election, claiming that the Election Commission issuing separate notification for holding by-polls for casual and regular vacancies in Rajya Sabha was in violation of the law. Earlier, the top court has said that it would like to give an authoritative pronouncement on the issue of EC's power on issuance of separate notification for holding by-polls for regular and casual elections to fill vacancies in Rajya Sabha. The pleas pertain to 2019 Rajya Sabha by-poll on 2 seats from Gujarat and both seats were won by BJP candidates. Jaishankar was elected to Rajya Sabha on 5th of July last year in by-polls held on seats vacated by Union Minister Amit Shah and Smriti Irani. Jaishankar had defeated Congress candidate Pandya in the by-polls. The Congress leader had moved the High Court, challenging the election on the grounds that the Election Commission's notification treating the two vacant seats to be of different categories and requiring by-polls to be held separately were illegal and in violation of provisions of the Constitution, the Representation of People RP Act 1951 and the Conduct of Election Rule 1961. The Gujarat High Court had, in September 2019, dismissed Pandya's plea. Pandya, in his appeal before the Supreme Court, has stated that the High Court erred in law by ruling that the election petition filed by Pandya was to be dismissed on the line of the ground that he was neither a voter nor a candidate in the election in question. It is Pandya's case that in order to fill up the vacancies so created, the EC was required to notify the vacancies under Section 147 of the Representation of People Act 1951, calling upon the elected member of the Legislative Assembly of the state of Gujarat to elect a person for filling up the vacancies. But only a single notification notifying such casual vacancies and calling upon the Legislative Assembly of the state to elect alternate candidates ought to have been issued by the EC. Pandya has contended that by following the process of dual election, the two vacant seats were usurped by the BJP. But if single election were held, then Congress could have won at least one of the seats. We will give you short date and it will be listed on non-miscellaneous day, the court said at the hearing, which was conducted via video conference. Bureau Report.
The Supreme Court has objected the way media reporting took place in Kerala journalist Siddiqui Kappan case. Chief Justice of India S.A. Bobde said that media reports claiming that Apex Court had denied relief to Kappan were unfair. The state of Uttar Pradesh has submitted before Supreme Court that journalist Siddiqui Kappan has no locus to approach the top court under an Article 32 petition, since he is not in an illegal custody or confinement but is in judicial custody in pursuance of the valid judicial order passed by the competent court. Kappan's detention has been challenged in the court.
The Supreme Court has taken objection to the manner in which the case challenging the detention of Kerala journalist Siddiqui Kappan was reported by the media. Chief Justice of India S.A. Bobde said that the media reports claiming that the courts had denied relief to Kappan were unfair. Senior counsel Kapil Sibal, appearing for Kerala Union for Working Journalists, who are petitioner, said that he had nothing to do with it and that unfair reporting happens every day. Solicitor General Tushar Mehta, who appeared for the Uttar Pradesh government, concurred with the CGI. He said, yes, there was inaccurate reporting. Such reports need to be clarified. During the previous hearing on November 16, the Supreme Court had sought the response of the UP government in the matter while orally remarking that it might send the matter back to Allahabad High Court as it was not inclined to encourage an Article 32 petition. Sibal had said that Kappan was not being allowed to meet even his lawyers, after which the court had sought UP government's response. The court eventually adjourned the case after Mehta told the court that there was no objection to Kappan meeting his lawyers. Kappan, a journalist working with the news portal, was arrested at a toll plaza near Hathras in Uttar Pradesh while he was on his way to cover the horrific gang rape and subsequent cremation of a 19-year-old Dalit woman. He has been charged with offences under the Unlawful Activities Prevention Act. A habeas corpus plea was filed in the Supreme Court by Kerala Union for Working Journalists, challenging Kappan's detention, claiming violation of his fundamental rights under Articles 14, 19 and 21 of the Constitution. The state government, in its affidavit filed on Friday, told the Supreme Court that Kappan, who is the office secretary of Popular Front of India, was attempting to go to Hathras to create communal and caste tension. He was using journalist cover by showing the identity card of a Kerala-based newspaper, Tejas, which was closed in 2018. Solicitor General Tushar Mehta submitted that Kappan was arrested and remanded by competent court and his bail plea was heard for 9 days. On October 12, the bench, which also comprised Justice A.S. Bopanna and Justice V. Ramasubramaniam, had adjourned the habeas corpus petition, asking the petitioners to approach the Allahabad High Court first. The Apex Court had also asked the petitioner to file an amended petition. However, the KUWJ has informed the court on Monday that not only has the case not progressed at the High Court, but Kappan was also denied the opportunity to meet his lawyers. The petitioner has sought the immediate release of Kappan. Bureau Report.
That's it for Courts This Week today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.